What's up, everybody? We are officially done with the defense's case in chief. We heard from experts today. Did they prove self-defense? Did they prove Ashley Benefield was in fear for her life or serious bodily harm the night of the incident? Did they prove it based on domestic violence facts, based on specifically Ashley Benefield's situation with Doug Benefield, the victim in this case? What do you think? We are going to react to and go through and break down all of the testimony from the defense's last day of putting on evidence. Tomorrow, we've got rebuttal, closing arguments. This case will be to the jury late tomorrow, early Wednesday. Let's get into it. So make sure you guys hit the like button if you haven't done that yet, and make sure you are subscribed to our page. We are so close to 415,000 subscribers, and we are working our way, fighting hard to get to 500,000, which is crazy to think about for a channel like this to get there. So thank you guys for coming, for hanging out, for watching these cases, for bringing your questions and making the content interesting, truly. But today we're going to start out with the witness that a lot of us have kind of seen some of what he's going to testify to, especially his background and his information. Is the domestic violence expert. He's a mental health counselor, not a doctor, and the state kind of makes sure to say, is it doctor or is it Mr. in the beginning of their cross-examination of this witness, just so everybody knows. But he is the one that is going to lay the background, lay the foundation. Is Ashley Benefield a victim of domestic violence? Does she fit into the battered spouse syndrome? If you're wondering what it might look like with Sarah Boone, if she had a great expert, or all the money in the world to hire whatever expert she wants to, as a private defense attorney did in this case, well, it may sound and look something like this. And to start off, we're just going to listen to him. You know, he talks about how 2/3 of abusers are men and 1/3 of victims are men, and obviously vice versa with women. But he explains this wheel of domestic violence and different things, and he explains how long lasting it can be. And so let's just listen to some of the foundation, and then we're going to hear him apply it specifically to Ashley Benefield.
On the screen, I will. So this is what's referred to as the Duluth power control wheel. And so there's physical violence and sexual violence. Those are the criminal things I talked about. And then there's these power control aspects. And the nature of the power control is repetitive. It's a way to get control. So up at, we'll call it 1 o'clock, using intimidation, making her afraid by using looks, actions, gestures, smashing things, destroying her property, abusing pets, and displaying weapons would be an aspect of intimidating your partner, again, to gain control.
So these are things that are in textbooks that when he teaches classes on domestic violence, this is what they teach, just generally speaking. They are not talking about this case specifically right now when they're talking about firearms and hurting yourself and asserting dominance and the victim placating. They're talking about prototypical, stereotypical domestic violence. What do victims look like? What do abusers look like?
Emotional abuse, putting her down, making her feel bad about herself, calling her names, making her think she's crazy, playing mind games, humiliating her, making her feel guilty. Then isolation, controlling what she does, who she sees and talks to, what she reads, where she goes, limiting her outside involvement.
So, and again, if you just think about isolation, that's not as much one in this case. I guess you could maybe argue, you know, he sent her away, but he wasn't controlling who she was hanging out with as much. I mean, I guess you can try to argue he is, but the state does a good job to point out a couple of these differences in this case, but then they kind of step in it as well on cross when we get there.
Jealousy to justify actions. Then a big one that I see often is minimizing, denying, and blaming, making light of abuse, not taking her concerns seriously, saying abuse didn't happen, shifting responsibility for the behavior, saying she caused it. Another one is using children, making her feel guilty about the children, using the children to relay messages, using visitation to harass her, threatening to take the children away, male privilege, testing, treating her like a servant, making all the big decisions, acting like the master of the castle, being the one to define men's and women's roles, using economic abuse, preventing her from getting or keeping a job, making her ask for money, giving her an allowance, making her ask for money, not letting her know or have access to family income. And the last one is coercion and threats, making her carrying out threats to do something to hurt her, threatening to leave her, saying that they'll commit suicide, reporting her to the government, making her drop charges, making her do illegal things.
So that is the wheel of control, basically, that is, you know, normal in domestic violence cases. And I just feel like the defense lined it up and is giving us the step-by-step evidence like you would expect the prosecution do to prove their theory. Okay. He talked about, like I said, introducing the child, ups the ante. She doesn't want to poke the bear. She's afraid, things like that. But then also I felt like some of the characteristics they would describe as like, oh, they're usually charming and they can trick people, but not all of them are charming. It's like, I mean, you could describe like any personality. I don't think one personality makes somebody an abuser, right? Just because this guy was charming, or that people didn't see it outdoors doesn't make me think, oh yeah, he must be. It's the specific acts and incidents of violence, which is exactly why they are admissible in these kinds of cases. That is what really kicks it up a level, is the things that he did physically to the pets with the firearms, to her, to the house, right? Punching holes, shooting holes, things like that. That's the much bigger difference to me than like that he was charming or people didn't necessarily see it from the outside world. Somebody said, did you see the prosecutor in Baldwin was disbarred? Holy cow. No, I did not see that. I'll have to take a look at that. Azam said, I'm so sorry if I'm wrong. Didn't she invite him that day? Her mom wasn't home. I don't remember if she did. She wasn't afraid of him. So does the battered spouse apply here? I'm confused. So they plan on packing the U-Haul together. Yes, her mom was there, but her mom left to go to the park. And that's part of this bigger picture. In order to be a victim, do you have to always be afraid? Do you have to never be in the same room with them? Do you have to never be in the same room with them unsupervised? Do you have to never let them in a room with your child? Because she was Googling and trying to figure out how to co-parent with an abusive partner. That's what she was Googling. So it seemed like she did everything, and this is the defense's theory, right? That she did everything she could, legally speaking, to try to get him away from her and cut him off. She lost at every turn, so she had no choice but to be around him. And this was one of the ways she was going to be around him. But I think if the jury thinks like you did, she invited him over there that day, which proves she wanted him there, she wasn't afraid of him, and this is not a battered spouse case. I think that's a discussion that's open for discussion as these jurors go back and deliberate. The next part, the defense is going to go through what they call a bunch of hypotheticals. Let me get my air quotes out. Hypotheticals that are very clearly the same set of facts that we have heard them discuss in this case, and actions that Doug took that seemingly are confirmed with physical evidence and other people's testimony. And they ask this expert, is this abuse? If somebody who's been through this, are they a victim of domestic violence? And I got to be honest with you, every time I hear the defense read or list off all of these prior bad acts by Doug, it's really hard to get over. And the prosecutors have to be sitting back there thinking, how are we going to get past this with the jury? What do you guys think as you hear the defense list this off?
So, Mr. Ferris, I'm going to give you a series of hypotheticals, and I'd like you to tell us if it's consistent with abuse.
Yes, sir.
Shooting a gun in the kitchen of a home in an effort to intimidate the victim to stop speaking. Throwing the loaded gun at the victim. Cruelty to pets. Punching a dog in the face hard enough to knock the dog unconscious. Throwing a cat down the steps. Placing a tracker on the victim's car, an illegal tracker. Throwing things, breaking things, yelling, screaming, belittling, cursing, humiliating. Declaring such statements as rid the earth, being in a murderous mood, kill all the bad people, take them out, being caught at night, peering into windows of the victim's home, violating a no contact order by sending a package, driving from South Carolina to Florida to be able to follow the victim, suicidal threats if the victim leaves, more than 30 years age difference, and finally, prior marital history whereby the prior wife explains how she was beat up on the honeymoon. Would that be consistent with abuse?
Absolutely. And not only
Like, well, when you put it like that, and he's basically asking this guy the ultimate question for the jury. Was she the victim in this case? Was that her mindset? That when he lunged at her, when he blocked the door, when he grabbed her, when he hit her in the face, when he bumped her in the hallway, is that why she thought the way that she did? That's what he's trying to present with this expert. And this expert's now going to explain exactly how that works.
absolutely, but those are checklist points right off the Duluth Power and Control Wheel, and right off my experience, they're stereotypical abuse techniques.
All right, and now my last question for you, Mr. Ferris, is I'm going to give you a hypothetical, You tell me if this would be consistent with someone who suffers from abuse. Sending texts that are conciliatory with friendly emojis, accompanying the
So now he's going to list off how Ashley Benefield has acted in their relationship and if this is indicative of being a victim.
Abuser during child time sharing ventures, acting deferential and subservient in joint therapy sessions, but decisively different in individual sessions, fearful of the abuser finding out the victim described him as controlling, manipulative, and abusive, and being exposed to threats, intimidation, pushing, holding down, humiliating, cursing. Would that be consistent with a victim of domestic violence?
Without a doubt. These are, again, techniques of compliance, not wanting to poke the bear, walking on eggshells, trying to minimize harm to themselves and their children. They'll put up a front. They don't want anyone to know, and they don't want their abuser to be angry by them disclosing. So, yes.
Lastly, one other factor I neglected to mention, would a video of the abuser and the abused at a restaurant with the child and another adult, whereby they are all acting happy, be consistent as well?
Well, certainly, if you're asking, they're acting happy, is she still a victim of domestic violence? Definitely. And it also fits with this whole idea of appeasement. We have to remember that the domestic violence comes in layers through the years of events. So one incident...
Judge, I'm object to non-responsive.
So that behavior isn't just a spot image right then. What's going on inside her? Why is she acting that way? That's what I would ask clients. That's what we're looking for. And if it's truly a victim of domestic violence, she'll be in this appeasement mode to try to please him and not disclose the abuse to get along sort of description.
My final question as it relates
Before we get to his final question, Mo said, Peter, when Ferris said sometimes they have great, nice personalities, he didn't mean just one of the symptoms as an abuser, but he meant they also have those traits, right? Like, meaning they can't, just because they have that personality doesn't mean that they're not an abuser. But I do think there's a certain thing where you can go too far to be like, anybody could fit into this, right? But when you have those specific instances of violence to pets and with firearms and things like that, that's the biggest differentiator, that then we can look back and see how somebody may manipulate, how a victim may act, how it might not look like that on the surface. And that's, I think, what they had in this case, the facts that they've developed that you don't just have in every case. You can't just say every guy's an abuser. That's not what's happening here in this case, in my opinion. They have different and additional evidence from that. All right, let's get to his last question.
general to domestic violence. Assume, hypothetically, there were several violent or semi-violent acts of domestic violence, and then there was a break in the chain of events for, let's say, as much as a year or two, and then it started up again. Does the victim remember, and is the victim affected by the earlier acts of abuse?
Without a doubt.
This is an important question. If the abuse happened in the past, does it still affect them in the present or even in the future? And this is going to be important when you hear the cross as well.
The victim remember, and is the victim affected by the earlier acts of abuse?
Without a doubt. I've got clients who tell me about
Yeah, just
so yes, definitely they don't forget the abuse that's occurred to them. Trauma lasting. Adults remember childhood trauma, let alone something from several years ago. Like I say, layers of impacts of behavior.
Thank you very much. No further questions from Mr. Ferris.
So that is the end of direct. It was kind of short and sweet. And Ted found that interesting. I have felt the prosecution's presentation of this entire case to be kind of baffling. Like, I don't understand. And we are pretty much going to listen to the entire cross, 15 minutes of cross, because this is the defense's big expert. This is who's saying that which way the domestic abuse went, right? And listen to this cross. I was like, what are they saying? What are they trying to prove with this cross? Before we get to it, let me answer a couple questions. Pity Mom, when you get there, can you explain why the judge didn't allow the DNA swabs from AB and DB in? I'm confused. Yes, I'll give you my best guess as to what happened, and parts of it I agree with, parts of it I do not. And I think the defense ended up agreeing also with what I originally agreed with. I'll just say one of the biggest issues I agreed with the judge on was they didn't really have an expert to explain what all that meant. And without that, you can't really bring that stuff in. I did not agree with the judge at all in the chain of custody. The state's definitely not objecting to their own chain of custody. If the defense isn't objecting, the judge should not keep it out because of that. Everybody agrees it's reliable and the chain of custody is fine. So if both sides agree, why are you going to jump into that? But I do agree you need an expert to explain what all those numbers mean. And then the defense, why I said they ended up agreeing with that is they tried to say, well, we can bring the expert in tomorrow. Judge, it seems like is not going to allow that. John said, this doctor reminds me of Dr. Spiegel from the Amber Heard trial. who called Johnny Depp a dumb individual while licking his lips. I disagree. I didn't get that vibe at all. All right, let's get to now the cross of this expert.
Minimizing the abuse.
Now you're asking me if the victim would minimize?
Yes. Like what I mean by that, and maybe I said it wrong, is like covering or taking blame for the abuse, covering for the abuser, taking blame,
Yes,
making excuses for him
definitely.
or her, I guess, but not reporting the abuse,
Right.
dropping charges if they were filed.
Yep.
Not standing up for themselves
Yes.
and not leaving.
Yes.
Okay. I'm going to put that wheel back up, and I want to talk to you about the high sections each.
Sure.
I'm going to talk first about the use of intimidation. Would you agree that if somebody, this says making her afraid by using looks, actions, gestures, smashing things, destroying things, her property. We talked about a break. If those things weren't occurring for years, would you, but had allegedly occurred prior to that, would you still consider that part of this dynamic?
Yes.
If it's been a distance in time?
Yeah, I think the distance can be totally irrelevant.
And
I mean, totally irrelevant is a little bit strong, but why would you ask that question if you're the state? I can't figure out why they would ask that question. The evidence has already come in through the defense, so it's not like you were the first one bringing it up, but why reiterate it? Why ask him that question again?
there's a section on here about the economic abuse.
Mhm.
Would you find that if a hypothetical victim was living on her own for several years, had no monetary dependence on the alleged abuser, and lived in her own home in another state for part of that, and there was no monetary connection, that would not apply to a relationship?
Could you restate the question?
So if in this wheel,
Right.
hypothetically, when I'm talking just about using economic abuse,
Right.
would you agree, would you say it still applies if the victim was living on her own for several years with family and independently sufficient economically,
Mhm.
no financial dependence on the other person? Would you agree with me that economic abuse would not apply to that relationship?
From the scenario you give me, it doesn't sound like it would apply.
You know what's crazy about that, right? So they say the economic abuse doesn't apply here because, she was living with her mom and he had kind of run out of money or whatever. Yet they talk about how economics was such a big deal, about how she was manipulating, why she wanted to be into this marriage. I just thought that was kind of weird. I was like, so wait a second. So how did that all work in this relationship as well?
And for isolation, would you agree that if it's the same facts, living on her own for several years with family, so I know it says isolated from family, I think, living on her own with family and having some periods of no contact for over a year, and then being back in contact, but living separately and having her own cell phone, having her own car, having her own home, would you agree with me that that's not a situation where there was isolation?
Well, you have to remember, under the isolation also comes jealousy and justifying action. So in terms of isolating, not letting their partner or the victim go to work or see family, in that sense, what you're saying is true. But a component of isolation could also be extreme jealousy, possession in your mind, those sort of things.
And
I think that was a punch that landed for the state. That made sense. We didn't have isolation in this case, but I think it's also something that he explained, that you're not necessarily going to see every single one of these in every single case, which I think most people understand as well. But I do think that was a good argument by the state that we don't have that isolation. Those are the kind of points you want to make. We don't have isolation. We don't have this. We don't have that. We don't have that, right? We just have kind of couples that argue and stuff he did in the past, but not in the present or whatever. Some kind of an argument like that is what I would have expected to see from them. D-Dub said, what's the total time of meeting each other to the shooting? A couple years. Because they got married, had the kid, and then it had been a couple years. I want to say, 2-3 years, something like that. I don't remember. I'm sure somebody in the chat will. Why do they call it DV when there's no violence? We need another term, DA, domestic abuse, and it does not justify killing. So I'll disagree with you a couple different ways there. Violence does not have to be, or DV does not have to be physical touching. I mean, if you think about assault, right? Assault in most states can be assault without touching. Right. And literally firing a firearm to scare somebody or to threaten somebody is assault. So I think there are these kind of violent crimes, even without physical touching. And I think there is also emotional abuse. And I mean, we have seen like children in some cases we've covered that have been emotionally just abused. And there's no other way around it. And it can cause horrible, horrible things. And it can cause people to get into situations where they are fighting for their lives. So I'll kind of agree to disagree with you about this. And then a bunch of other people are really, sharing their stories and how Abuse can look different and victims can look very different and deal with it in different ways. And it's not always rational. It doesn't always make sense. Now, that can make it hard to prove in court. And we want legitimate facts. We want legitimate proof and not just, a he said, she said at the right moment and at the, time where it's good for one person or the other, which sometimes it still is true, but it looks that way. We've got a lot more than that in this case. A lot more than that.
Didn't add those facts. You're adding those facts, right?
Well, under the power and control world, the last item, I don't know if you actually mentioned it, using jealousy to justify actions.
And if that was not a factor, that's not a factor.
Then isolation component may not be part of that, component for the scenario we're looking at, the couple we're looking at.
And why do you say may not? What part of that would apply?
Well, would not be.
Okay, thank you. Using the children. If the hypothetical victim had custody of the child and attempted to terminate parental rights, and the hypothetical abuser had to seek court intervention to get the child,
right,
would that be a factor in your consideration of whether children were being used? If she had sole control of the child.
So you're asking me, if I could just reframe, that the alleged abuser is not he's not using child against their alleged victim, then they're not necessarily guilty of using the children.
I'm not asking if it's guilty. I'm just asking if that would apply. We talked about how these things apply.
It may not apply. It would not apply. But I think if I could mention, you're missing the point of the power control wheel. This is about pattern of behavior.
I'm not missing it. I'm just asking hypothetical questions. How about the using a male privilege? If that hypothetical abuser was not having any control over her big decisions or did not live with her, so was not being the master of the castle, was not treating her like a servant because they lived separately, and was not defining their roles, in fact, was offering to purchase things, get her anything she needed, those kind of things. Would you agree with me if those were the facts of a relationship, male privilege would not apply?
No, I wouldn't agree with you.
Okay, can you elaborate?
Yeah, the men's roles. And when you say purchasing things, I would want to look in.
Never would I ask an expert like this to elaborate. If he said no, he disagreed with me, I'd move on to the next one. The jury heard my question. They should understand where I'm going. I would never ask this guy to elaborate.
To what is that a concept of what the role is? I'm the man. I purchase things. I control things for you. I decide what to get, et cetera. So that could be a male privilege issue.
Okay, and I understand that. And that was 4 facts scenario in mind. I think it kind of goes with the economic abuse. And what I should have asked is if she's asking for, can you stop and get me boxes, or can you stop and get me tape, or can you stop and get me something else? And he is, yes, of course, and he does it. That's what I'm talking about, not him telling her what she may have.
So in terms of him buying things for her that she's asking for, I wouldn't consider that to be domestic violence.
Okay, you would not?
No.
Okay.
Like, yeah, duh. He's basically thinking in his head, that's a bad question, and it gets worse.
So that's, other than that caveat, then male privilege wouldn't necessarily apply to the cycle that we're in, under my facts.
The facts are not complete enough for me to come to the conclusion.
Okay. How about minimizing, denying, and blaming? What you said that was present in 90% of the cases.
Quite a bit, yes.
Right. I think you said 90.
I did.
What if the hypothetical abuser says, I was wrong. I lost control. I shouldn't have done those things, and never says it was your fault you did those things? Would you then feel like that's not minimizing, denying, and blaming?
No, I wouldn't agree with that.
Okay.
Because it could be that part of the strategy of minimizing could be that I'm sorry I didn't do it. That could just be minimizing.
I'm sorry I didn't do it. I'm sorry I did it.
Right.
That's part of minimizing?
Yes.
So now they're wading in the waters of, he even apologized for his violent behavior towards Ms. Benefield. He didn't blame her. He just apologized and said he wouldn't do it again. And this guy's like, yeah, sometimes that's part of their strategy. They don't always blame the victim. Sometimes they just want to, bring them back or manipulate them or whatever. So they'll apologize. They'll say they'll never do it again. It's like, I think a lot of people know that about abusers, that they apologize and say they'll never do it again and promise, and then it happens again. But she's now, in her questions, in my opinion, in her questions, she is starting to admit that at least at some point, Ashley Benefield was a victim. Correct me if I'm wrong. I know you guys will, but that's what they start to sound like to me in some of these questions.
Well, certainly not denying or blaming, right?
I would need more definitive facts.
I need an explanation on if somebody takes responsibility for accusations against them,
right,
that is minimizing. Just to say, yes, you are correct. And I'm sorry.
It could be a way to dialogue or to minimize what occurred by accepting blame for it. And that could be part of their scenario.
Could it also be the opposite?
Yes,
that person is taking responsibility for their action.
Right. Certainly it doesn't deny that it happened. That's for sure.
Right. And no blame being set forward if they say it's my fault.
Well, just because someone apologizes doesn't mean they weren't abusive.
I'm just talking about the factors.
It sounds like they were abusive if they're apologizing for being abusive, right?
Wheel.
Right.
And whether or not, if somebody under my hypothetical admits to responsibility for the accused abuse and apologizes for that, whether or not you would consider that denying and blaming.
I would need more information on the relationship in the scenario to decide that.
Is there a scenario? Okay. How about using emotional abuse? If there's no accusations of any name calling or telling her what to wear, this hypothetical victim, in fact, she's comfortable enough to wear a sports bra and shorts around him. There's no displaying weapons. I'm sorry, I'm looking at the wrong one. No evidence in their relationship of playing mind games or humiliating her or making her feel bad about herself. Would you agree with me that that might not be a factor?
Well, you gave me a discrete list, but emotional abuse also includes name calling,
Okay.
putting someone down, affecting them emotionally.
I guess, is there a scenario, Mr. Ferris, where you will agree with me that a relationship might not include emotional abuse? Because I don't know how to give you enough factors for you to say, no, it may not.
I can't help you with that. I'm not asking the questions.
Oh,
That's never a good sign when an expert says that. I can't help you with that. I'm not asking the questions. I mean, her hypotheticals just are making no sense. She's not putting all the facts in there. If the jury is paying attention, they're like, what is happening? It's not going well. It's not going well. And I feel like she's making admissions that at some point Ashley Benefield was a victim, but no longer was the night of the incident because she could wear sports bras and invited him over, which some of you guys are saying in the chat. I mean, it's interesting. And I see some people disagreeing in the chat, and that's fine. We can disagree. I also see people saying, let's not rip each other's heads off. Let's not do that. Okay. Let's not rip each other's heads off. Let's disagree with facts and explanations and logic and how we think the jury's going to view this.
I give you enough factors for you to say, no, it may not.
I can't help you with that. I'm not asking the questions.
Oh, I was asking you one.
I know I'm not. You are.
Would you take into account, based on with these factors such as emotional abuse, economic abuse, male privilege, using children, all of these, if the alleged victim, let me give you a scenario. She does not live with him. She's actually in another relationship, potentially engaged to a new man.
Okay.
She tells him that she does not want to be with him.
Okay.
And she plans to move away without him. Would those be factors that you would have to take into account when deciding if that relationship fit this power and control?
Well, that would be factors of the relationship, but I haven't heard you say anything about what their history is, what trauma she's experienced, what's going on with children in their lives, all sorts of other dimensions of the relationship.
I guess, so are you...
And he's not bringing in, he's not saying, and this is why I would say, if this guy was my expert, I'd be like, did a good job handling this, because he could have pulled factors like, well, we don't know if she was from the moon, or, if her parents were abusive, or if she witnessed an abusive relationship between her parents. He's not bringing in factors that this jury hasn't heard. Instead, he's bringing in factors that apply to this case. Like, what was their past? Did she have trauma in the past? Was the child part of that trauma? Because you remember Ashley Benefield, her mindset, that he was abusing the child as well. And if you want to say those allegations were total BS and unfounded, okay. But he's talking about Ashley Benefield's mindset and what that was at the time of the incident.
Is there no scenario where there can be abuse in a relationship and then there no longer is abuse, where they are no longer in this wheel? Because the way you're answering your questions, that's the impression I'm getting.
So there, I have come across situations where there's an emotional abuse or a physical abuse, but it's not a pattern of behavior. It doesn't go on over a period of time in an attempt to control someone. So if someone pushes down their girlfriend on a night out and he gets arrested for domestic violence because they live together, it's a battery, that's domestic violence. But that's it. She's not appeasing. She's not put an emotion, the whole power control dynamic isn't happening. That is domestic violence under criminal law, but it isn't domestic violence in the sense of a pattern of behavior to try to get the appeasement or the sort of consensus out of a victim where they're afraid to poke the bear, all the things I've already talked about.
But he would testify that it can start the ball rolling towards that. That can be one of these incidents that does grow into domestic violence. And that's why he's saying we have multiple things here that layer on top of each other. And Finkel wide right, great reference. I agree. It's tough. It's very difficult.
If that answers your question.
It didn't. Is it your testimony?
Did that answer your question? She said it didn't.
That once a relationship has these power and control aspects, that is forever, even if there's no continued allegations of abuse for years, no continued allegations of abuse, no continued allegations of emotional abuse, never any allegations of sexual abuse. The parties are living apart. They're independently, I keep saying independently wealthy, that's not what I mean. Economically independent. They are, the female is telling him she doesn't want to be with him and has moved on to a new relationship. Is there no scenario, in your opinion, where people can get off this power and control wheel, even if they were on it at some point in their relationship?
I think it's possible, but it's not likely, and it's not the typical thing that I see. Usually there's still a dynamic of emotional abuse.
So even under my facts,
Yes.
with no allegations,
Yes.
no allegations of emotional abuse in years,
No.
it's your opinion that not good enough. They're still in this power
Well,
program.
I can speak from my critical learning and studying this, and also my practice. And I have custody issue couples where they're domestic violence, and 10 years later, there's still abuse taking place, even though they're remarried and don't live together. So by example, I see continued abuse.
I mean, everybody knows that. I shouldn't say everybody knows that. That was maybe condescending. I have people in my life, whether it was a parent-child abusive relationship or an abusive relationship they got out of, that whenever you see that person or you're around that person or that person gets brought up, there is still something going on and feelings there. It's not like it just went away because you haven't seen each other for a couple of years or because you're married to somebody else. So I don't think that's that far-fetched personally for victims to continue to deal with it after the fact.
Could there be a couple that don't? I'll say it's possible.
Thank you.
Yeah, it's possible for it to go away, but it doesn't mean it always goes away just because of time. All right, and that was it. That was Cross. I'm going to hit some questions here. Brendan, what is your overall impression of the judge? I really admire his demeanor, but sometimes his decisions feel narrow, cuts defense, no breaks fairly. I think I like his disposition. I like his demeanor. I like that he's not afraid to make a call. I like that he says, you argue, you respond, and that's it. And he kind of cuts him off. I haven't agreed with some of his decisions though either. So I get where you're coming from there. Tangling with Gina, does the defense have to prove she was in fear for her life for her to be not guilty? So no. The state, once the defense raises and puts evidence on of self-defense, the state has to disprove. They have to prove she was not in fear for her life that night beyond and to the exclusion of every reasonable doubt. So the state has to prove. And I see a bunch of people in here saying stuff like, Kathy, Peter, I'm still over here wondering why she killed him that day. I currently see it as M. I don't see self-defense. So that's fine. That's fine. Did the state prove to you that it was M? Did the state prove why she did? If you really want to know why, the defense has given you a reason why. What's the state's? Why did she choose that night? Do you believe it was about, protecting that report from never coming out for 3 days? And if it wasn't that, then what was the reason? Why did she pick that night? Why did she pick then? Because maybe neither side has proven it beyond a reasonable doubt. And then, exactly like Azam said, based on your video title, if the jury thinks both parties failed to prove beyond a reasonable doubt, they should still vote not guilty, right? Yes. The defense doesn't have to prove self-defense beyond a reasonable doubt. They have put it forth enough, in this case, for the state to have to disprove it beyond a reasonable doubt. Melanie asked for a poll at the end of the video. Yes, we will do that. At the end of the defense's case in chief, we will put up a poll, but realizing there's still one chunk of evidence left with the state's rebuttal case where they're going to try to disprove this self-defense beyond a reasonable doubt. Zezla, can you explain why Doug admitting to everything through text wasn't enough? Going through something similar, and I just don't understand, wasn't enough for what? Sorry. I think it is enough to prove that there is some domestic issues. It's not necessarily enough to prove a crime if, I guess it could be animal abuse and things like that, or it could be assault. But I guess I don't know how they relitigated it. To me, if I was a prosecutor and I saw these texts, I would at least investigate and see what's going on. The expert even said, ask better questions. I feel like he was trying to. Jilly, her cross sounded like, yeah, these are the facts, but what if they weren't? And then you would say, and then he was still like, I would need more facts, honestly. John, is he qualified to use the SM5 evaluation or whatever it's labeled as? They didn't ask him about this. So this was reliable enough to cross the bar because they did a Daubert challenge and the judge felt he was qualified enough to answer these questions. And this is the evidence that went before the jury. Such is the wheel of abuse. It's a wheel, prosecutor missing the forest through the trees. I mean, I don't even get the trees that she's looking at, Finkel. I honestly don't. Nikki, 50-50, but state not proved this wasn't self-defense, in my opinion, so not guilty. Yeah, I'm not saying that they have proved this self-defense case perfectly or that it all makes sense and it's all perfect. But to me, they have enough to where the state needed a better case to win. That's kind of where I'm at. The state needed to do a really good job to win this case. And I don't feel like they've given us any, and we're about to go through other experts for the defense. And all I was thinking is, why didn't the state have any expert like this? Why didn't they give us this explanation to at least give us something to compare? Because it's not supposed to be comparing apples to apples, right? The state's got the burden beyond a reasonable doubt. But at least, some juries think, okay, who's more likely right? We hate that as criminal defense lawyers because that's not the burden. But if you have two stories and you can pick one that's usually right and one that isn't as right, sometimes they'll go with that. I don't feel like the state provided us that story in this case. Christy, Peter, is there a lesser charge that might have been more appropriate, even for those that don't believe her story? Second degree definitely was not proven here. I think they're going to end up having manslaughter as a lesser included. In this case, Florida usually does that. So that's what I would expect here. I think the prosecutor should go to law school. I think they have gone to law school. Daybreak, on another case claiming self-defense, will you be covering Susan Lorenz? So I know nothing about it. The way I found out about this case, I knew nothing about it, even though it was literally in my backyard. You guys asked. Whoa. Fireworks. These like automatic things that happen sometimes when I thumbs up, it does like a thumbs up emoji. That was cool. I don't know why that happened. But if you guys ask me for it, I will do it. So if enough of you want to talk about this case or whatever case is coming next, you guys let me know. You choose the content here. All right. Let's jump to the next witness, which was Stephanie Murphy's old employee who read an email from the JA that basically told them the detective was telling them the no contact order was in place on November 3rd. But on cross, she was like, yeah, there wasn't enough there to make an arrest. It wasn't in the system right, some weird stuff. So I don't know how hard that one hit for the defense. Next was Vincent Vizzacaro, who was a realtor who, after a bunch of sidebars, ended up testifying that Doug was looking at the house very close to Ashley's house, like right behind it-ish. And while the no contact order was pending, and he was saying he was going to try to buy that house or rent that house. But I thought the state did a good job on cross to say he said he was going to ask Ashley first and check with Ashley first. So I thought it seemed like a good point by the defense, but I thought it was mitigated well by the prosecution with their questions. Then Dr. Quintal took the stand again. And it's not surprising that he's back. And I was wondering if he was going to be a home run witness for the defense. And we're going to listen to a big chunk of his testimony here. And you tell me how good he really was for the defense, or if it was kind of a nothing burger or fell a little flatter than potentially it could have.
Same objections? Same objection. All right, I will rule the objections goes to weight, not admissibility. Go ahead, sir.
Thank you. So, Dr. Quintal, all right.
This guy was already called during the state's case. He seemed to be friendly for the defense. Defense calls him again to basically talk about the relationship dynamics. He's a mental health counselor as well. This is expert testimony.
We're rolling.
Okay.
Did you reach any conclusions with respect to Douglas Benefield?
Yes.
Would you tell us what those were?
Based on the conversations with both Ashley and Doug, Doug occurred as someone who was domineering, and the terminology that I would use at times would be super controlling. He was very dedicated to wanting the relationship to work. He was very interested, despite conversations with some of the disparaging things that Ashley had said to him. He was very much still wanting this to work, and their plans were to move to Maryland.
So I will tell you right now, after listening to this a second time now with you guys, I would have stopped asking him a question. I would have been, okay, thank you, sir, nothing further. I would have been done. He keeps asking, and I feel like it starts to fall flat. But that was the only answer he really needed. Super controlling, all of those things he said about Doug. That's really all he needed.
Right. Did you reach any conclusions with respect to him being a real alpha male? Do you recall?
I would say that Doug occurred as somebody who was very built and well put together. And yes, I would say that he would fit the stereotype of an alpha male, in my opinion.
Did you conclude whether there was an intimidation issue present?
Ashley stated that she was scared of Doug.
And so he seems like he's a straightforward witness. He's like, the only way I would know about intimidation and that stuff is what Ashley said. And that's what the state gets out across. That I think they did a good job that a lot of this information just came from Ashley. Which is what they said in opening would happen with every witness. I definitely don't feel like it's happened with every witness, but they did get that point across well with this witness.
Reach any conclusion, Dr. Quintal, about whether Doug's depiction of himself as being godly was reliable?
Objection outside of expertise.
Oh,
You can answer.
Can you say that again, please?
Sure. Did you reach any conclusion with respect to Doug's presentation of himself as being particularly godly?
Yes, I think it was over the top.
All right. And did you reach any
I
conclusion
don't understand how this helps you as the defense. And it's just it was kind of clunky.
as to whether it was genuine?
I did not think it was fully genuine, no.
Did there come a time when you inquired of Doug why he would want to remain in this relationship?
Yes, I did.
Why did you do that?
Ashley had a lot of disparaging comments, stuff with CPS, claims of abusing their child. And I was concerned and curious why, with all of that negative stuff that may even negative affect his job and career with government, why he wanted to stay.
And was it true that you felt he was hell-bent on being together?
I know that he really wanted the relationship to work.
Did you conclude that he was never going to let her get away?
I don't know whether that's true, whether or not. I don't recall that.
All right, let me pass this to you and see
Please.
if it refreshes your recollection.
Thank you. Yes, I said that to the detective. I said it seemed more like I'm not going to let her get away from me.
Referring to Doug.
Yes, sir.
All right, and lastly, Dr. Quintal, did Ashley have anything to say to you about Doug's interest in Emerson and whether or not it was just as,
Objection, hearsay.
Sustained.
did you reach any conclusions, Dr. Quintal, about Doug's interest in the child as opposed to Ashley?
Objection, Judge.
I'm going to sustain this to the opinion.
Was there an incident on one of these occasions when Doug was in your office that you thought was very strange as it related to the child?
Objection, relevance.
Overruled as long as it's factual.
Yes.
Can you say that question again, please? Thank you.
Was there an incident that you observed that you found particularly puzzling between Doug Benefield and the child, Emerson?
Yes, at the time that I spoke with the detective, I had an appointment and Doug had waited in the reception area, and it was a couples counseling, and Ashley was out in the car with the child. And I thought it was unusual that he didn't go out and see her. Given that they had the relationship they had, it may not be as unusual as I thought, but I was coming from having two little girls and what would be in my mind to do.
And how long was Doug sitting in your office at the time? Do you recall?
Well, it would have been at least an hour. I don't know how long I was in the appointment before.
And in that hour, from what you observed, with Emerson, the child, outside in the car, Doug Benefield never once went out to say.
I wouldn't have been able to observe that because I would have been in session. I just knew that he was waiting in the lobby. I don't know whether anything other than that.
Again, I just thought that kind of fell flat, and that's kind of where they ended. People asking, will you cover the Apple River sentencing? Yeah, Kelsey put that on the list. We'll see if that works out in our schedule to cover. Somebody else said Madeline Soto. And again, if these are the cases you guys want to see, let me know. And then Alexa Treviso, we have already covered some of that, and we'll probably very likely continue to cover that case. Andrew, hi, Peter. Does the prosecutor get to recall Ashley to the stand again? No. They got to cross-examine her. That's it. They don't get to recall her. How could he ask Ashley with the restraining order? So, again, I represented a bunch of people in criminal cases that violated restraining orders in relationships like this. And usually the victim's like, okay, fine, we can talk or whatever until it goes bad. And then they call the cops and you violated the restraining order. I don't know if they had that kind of a relationship, but maybe he meant after the restraining order was not in place anymore. Maybe he would say he didn't know that the restraining order was in place. I don't know, but obviously he shouldn't have been contacting her. But it seemed like he was sending her packages, planning to move near her, all while there was a restraining order in place. He said he needed to ask Ashley first. Why didn't he ask her before he wanted the house in her backyard? Obviously, she said no. Okay. Again, there are multiple ways to look at all this. I just think it's better to have said, I was going to ask Ashley, then I'm just going to surprise her and move in back behind her. But not good either way if there's a restraining order. No contact order. Hot Honey. The proof as a juror I'm still looking for is that he abused their daughter. That was what her fear was, and all her injunctions, was it not? So no, I don't think that is what she would say her fear was that night. She didn't mention anything about it that night, the night of the incident. He shoulder checked her, hit her with the box, hit her in the face, grabbed her by the hand, blocked the door, wouldn't let her out, lunged towards her. That's her testimony. You don't have to believe it. And by the way, people in the chat, if you don't believe her testimony, that's part of a juror's job. If you don't find her a credible witness and you start going down the road of thinking that she's guilty and the state proved it, that's fine. But I'm just saying she did say those things. And the defense is putting forth the case that she was in personal fear for her own life, not her daughter's life that night. Allegations in the past, sure, but not that night. Donna said, I would have been scared of this bloke because of his behavior. I mean, the defense is certainly painting him that way. I will say the defense is definitely painting him that way. So if it's not true, it really sucks and is sad, but they're definitely painting a picture where I agree. He definitely seems like the aggressor here. Yeah. I see a bunch of people saying Adelson as well. We will definitely be covering Adelson like we did last time for sure. Fishy, women not believed is the crux of this case and the reason Doug is dead when he maybe could have received help. And Brian said, hey, Peter, how is it possible for the prosecution able to not use the lead detective and then not allow the defense to impeach him on his bias reputation? So is that the next witness? Yes, that's the next witness, the lead detective that the defense wanted to call to just basically say he thinks every homicide is an M and he did all this stuff wrong and they just want to impeach him. And you can't just call a witness to impeach him. You can ask him facts. You can talk to him. And if you impeach him, you impeach him. He did get to ask that, I think it's strange that the state didn't call you. I think that argument's appropriate in closing argument. It seems like the judge was not going to allow it. This guy did ask, even though the judge kind of said not to, and the state asked for sanctions, saying the defense lawyer continuously disregards what you say, judge. So sanction him, which I found to be, okay, a swing at him. He doesn't seem to be bothered. So we'll see if the judge sanctions him later. The cop ended up being kind of a nothing burger. Tried to talk about how bias meant that Ashley didn't have a depraved heart because he didn't check the box for bias. State brought up that bias is usually for hate crimes. The cop basically said, I never use that bias box. I don't even really know what it means. I thought he was kind of a nothing burger because the jury obviously didn't hear any of the arguments outside their presence. So it was a little bit different. This subject matter can trigger big emotions. Trauma is real. Be kind. Looking through a legal lens, definitely reasonable doubt. Karen, I agree. And I really hope the chat can continue to do that. I know some people don't like when the chat disagrees with them and they don't like if people are direct, but I also realize people are sometimes nasty in comments. So let's not be like that. I don't think it does anything to prove your case or open conversation or learn anything if you're nasty in the comments. So just don't be, okay? It makes it more educational and uplifting for everybody, even if we disagree. And especially when we're talking about very difficult topics like this. All right, next, let's listen to, Michael Haag, forensic scientist, talks about his background. He testified at the Aaron Hernandez trial, and he talks about how he does shooting reconstructions. So once again, an expert I wish the state had. Show us what the trajectory of the bullets mean. If I have to hear another, side eye from the state about the bullet wound in the leg as if it's, disproving the defendant's case, but what does it mean for your case? Why is that good for your case? What is your theory as to why the trajectory of the bullet was like that in the leg? The defense has an explanation. Do you believe it? Maybe, maybe not. But what's the state's explanation for that trajectory? Somebody maybe can explain it to me in the chat. But let's listen to some of his reconstruction of these events.
We make assumptions in science all the time. It allows us to make further steps. So for example, we have two trajectories through the body. We have two trajectories into objects in the crime scene. If I look at the trajectories just within the crime scene, one that has to go through that long hallway and one that we actually do have some data for to figure out where the firearm was that just goes into the wall within the bedroom. And we look at those two trajectories, they don't overlap, meaning there's not a physical possibility for the firearm to have been stationary between just those two shots. I can't tell you with regard to sequencing which one was first, but if you make an assumption that the firearm, if you're the firearm, I mentioned right to left, moved from right to left, then the one down the hallway would have to have been before the one into the wall, if that's the hypothesis. If we take the opposite hypothesis, it's opposite left to right. That's where witness statements come into play to evaluate whether or not the physical evidence supports or refutes a witness statement. You never take a witness statement, and in my line of work, believe it. You look into what the physical evidence supports and then cross.
I mean, how about that? If you're the jury, you never just take a witness statement and believe it. That goes right in the face of what the state said. And maybe the jury can be like, forget about what everybody said, including Ashley Benefield. What does the evidence tell us? And the defense is presenting a theory backed by science and backed by the evidence and the crime scene photos with an expert to say that all backs up this story in self-defense and corroborates. That's what I'm saying. You don't just believe Ashley Benefield just because of what she said. And it's hard for me to say somebody's lying or somebody's telling the truth. But this is the type of corroborating evidence that usually helps me make a lean in a situation like this. And once I'm starting to lean that way, the state's got to prove it beyond a reasonable doubt. So it becomes pretty hard. And I'm sure there's going to be people saying I'm always on the defense side and whatever. But I mean, I got to be honest. So let's just for a second take a timeout. Timeout like Zach Morris used to do in Saved by the Bell. The most interesting cases, in case you haven't wondered, and the ones you guys asked me about the most, are the hardest ones for the state to prove. When it's a slam dunk, the state's going to go in there and bulldoze somebody. Usually there's not a lot of questions. Usually you guys don't ask for me to cover those cases. I will if you wanted to. That'd be fine. Like we have done it, like Chad Daybell, Letitia Stock. Those were kind of bulldozing, in my opinion. And you guys had questions. But the vast majority of cases you find interesting have some kind of an element that makes you say, is this really what happened? And so those are the more difficult cases to prove beyond a reasonable doubt. So that just might be why you feel there may be liens on certain cases. If proven self-defense is life insurance payout, only asking because couldn't that be a motive if the claim of self-defense due to their lack of track record? No, usually that's not in there. I also, I don't know that there was a life insurance policy, that she was the beneficiary on it. I haven't seen any evidence like that come out, so I don't want to mix that in too much into this discussion.
Let's compare them. So if you have information or an opinion or a statement that the firearm was indeed in motion from right to left, the physical evidence for those two trajectories would support that. As far as the body, for me, this case doesn't help too much because I focus more on the scene in this case. Others have focused on the body. But with regard to the scene itself, or the body itself, certainly we have an idea of where the firearm was relative to that body. But because those bullets don't then continue on to hit other things within the scene, I don't particularly have an opinion there that would lead me to allow me to then say sequence those in order.
Do you have an opinion as to whether or not the deceased was stationary or moving?
If we assume that the firearm was relatively stationary, and by that I don't mean a matter of 3 or 4 feet, I mean the firearm is not circling about the room, going out in the hallway of this incident, or otherwise. If we take the position that the firearm is generally just in the bedroom and is pointed in the same relative direction as the two trajectories that I've described for you, then it would have to be that the decedent was in motion, because we have trajectories in the decedent's.
Now we're starting to talk about Doug was moving. And again, this is layering on top with what we're going to get from the medical examiner next. But we know kind of Doug was moving, and she gives us some explanation of to where Doug was moving and how he was moving. And the defense is really putting these pieces together. I got to be honest. They're putting it together better than I expected. So LC3, my only pushback here is maybe they don't understand it the same, right? It doesn't mean they don't understand it at all. But I will say that's not a prerequisite to being on the jury. So you don't have to have experienced it to be on the jury to make this call in this case. So while I do agree different perspectives are important and you know, people understand it differently for sure that have experienced it, but that's not a prereq to be a jury on this case. Ted said, I'd like to point out that during this expert testimony using the state's report, the ticker, I don't know what the ticker means. The ticker still says the medical examiner believes he was shot in the back. So we watched the medical examiner, the state's medical examiner testify. It was like right here, like by the nipple or something, like side front, definitely not in the back, but also not, you know, center mass in the front. Kelly D said, I became a member, couldn't wait for a random gifted membership. Watched your video for 4 months ago with your beautiful wife. It was great. Your dad did too. Going to have to talk to you about your view on dogs. Oh, I know. I'm a disappointment. Kim R, his dad, Luke Haag, testified in Rust. That is a great connection. Love it.
Body that are almost opposing. We have one that goes from, as described in the autopsy report, and this is how it's commonly described in such things, front to back, right to left, and as I recall, relatively flat. I think it was maybe slightly downward, but I've forgotten the vertical component. But the key factor is that one goes this way, and as I read the autopsy report, the other gunshot wound enters the inside of the right leg and comes out the exterior outside of the right leg. These are basically two relatively opposing trajectories on an object that undeniably, in my work, objects' bodies regularly move in between shots for one reason or another. So given that, to me, those trajectories in the body indicate to me that the body was in motion.
All right, and with respect to the firearm itself, are you able to draw any conclusion whether or not that was in motion as well?
Certainly within the degree I've described before with the two trajectories that I can show you, the one that goes in the wall, for those that I can demonstrate by physical evidence, there was some motion. And as I recall from my measurements in the 3D scan data, it's something like 4 or 5 feet, at least from one position of one trajectory's area over into the area of the other. As an approximation, again, because again, trajectories are approximations. Otherwise, beyond that, no.
So would it be safe to say that your conclusions support the fact that both the deceased as well as Miss Benefield would have been moving from right to left?
I can't tell you that the firearm moved from right to left of those shots. A statement of such would be supported by those two trajectories that I mentioned.
So the science and his reconstruction support Ashley Benefield's version. That's corroboration. Then they get into kind of where the shots went. I don't know personally if I thought these demonstrative aids were great. You guys tell me if you thought they were. I could picture some of it, not others, but I did think it was cool how we used the actual photos from the scene and stuff, but I thought this was kind of mid, but I want to play and see what you guys thought. And then we're going to continue playing to listen to the cross as well by the state.
And from this vantage point, you can see how there is a downward component to these shots as well, going into that, I believe, again, number 11 hole within the bedroom.
Would that be consistent with Miss Benefield firing the weapon while she's standing in the upright position?
There are certainly multiple places along these cones where a shooter could be standing. So basically any hypothesis or any scenario that puts the gun in those cones, including that one, would be on the table. So we've seen the up and the down, the vertical component here. We've looked at the azimuth, the left and the right from above. What I'll demonstrate for you now with the data is I'm going to take you to the right.
If I may, Mr.
Please,
Hagan,
yeah.
as to that bullet, for the trajectory that you've just shown us, there was no indications that it had struck tissue. Is that correct?
That's correct. And I'll show you that picture of that bullet eventually. But this bullet, based on the damage that the bullet shows, as well as the nice round hole going into the wall, this is a miss of the decedent. This did not strike the decedent. If I take you to the side of the cone here, the far right side of the rightmost cone, our most right option, from that position directly over it, if you look down the hallway area, you actually, there, fill in, you actually cannot see where that bullet struck the wall. This area right here is to the right of the bullet's impact site. We actually have to move, as I will now, over into this area.
And like, while this wasn't perfect, Jamie's point is well taken. Like, I don't even know what the prosecution's theory is. I guess they're just trying to go common sense. Like, she didn't like him. She wanted to take him out. She wanted to be a single parent. So she fired the weapon that day at him. And it's just as simple as that. And nothing else really, because there was no text that I saw where it was like, I hate you. I'm going to hurt you. I'm going to do this to you from Ashley to Doug. No past acts of violence from Ashley to Doug. No threats in the past. She never pulled out her firearm in the past. She never shot a hole in the ceiling. She never threw a loaded weapon at him. So all those times in the past, she never did that. Why did she do it now if she was just going to, you know, she hated him so much and she wanted to do it now? All because that report. I just don't buy that report, in case you can't tell from my tone. I just don't buy that report. And I just don't feel like the state has put together the picture for us, even as well as the defenses have. And that's not how we're supposed to not compare them. But even if I do compare them, they come up short to me. We'll see if, so people said, Peter, she wanted him gone, bottom line. Okay. I mean, that's, you're, in my opinion, you're taking a leap on that based on what the evidence has shown, which is not, you're entitled to do that as a juror.
I'll get us right at the edge of the wall. We have to come all the way over here in order to get to the impact site, which from my examination of images is more in this area. So somewhere on the tile in here is a bullet impact site, a ricochet off the floor. That bullet goes on and then barely perforates the drywall, or penetrates the drywall up in this area. So,
And that's another bullet. Is that correct?
correct. Sorry, I'm on to bullet 19, as I recall, was its designator for those two.
Let me recap for just a minute. So one goes in the wall, and then one goes down the hallway.
That's correct.
And again, you can't say which shot was first or second.
I don't have physical evidence that would allow me to establish that, correct. But that bullet in the wall down there also expresses no soft damage. It is also one that did not strike the decedent.
A miss.
A miss.
All right.
So from the 3D laser scan data, and I don't have a good trajectory or a good impact site to look at here. I was unable to go in and examine the floor. If I'd been able to find that impact site, I might have been able to refine that trajectory into the wall a little bit better and give us a more defined trajectory.
So, Banana, Doug is not here to say that, but other people are corroborating these comments from her, and Doug said it in texts. So they have all the texts between Doug and Ashley. So if she ever admitted to it or said it, or he said it to her, that stuff would have come in. If his daughter would have seen it, that stuff would have come in. It's not just one person saying this happened.
But other than the ballistic accessibility aspect of going down that hallway, I can't do that here. Just they're two separate trajectories that have some slight divergence in the lateral aspect.
Did I ask you what the degree of accuracy is for trajectory reconstruction?
I think we covered that, Turf, just that plus or minus 5 degrees is an industry standard. And based on having shot a lot of stuff, including walls, for a trajectory like that, assuming the trajectory rod was placed properly, about plus or minus 5 degrees is appropriate.
Did you have an opportunity, Mr. Haag, in preparation for your responsibilities in this case to interview Ms. Benefield?
I wouldn't describe it as an interview by me. I was certainly present while she described the incident.
And with respect to her
I
description
like experts like this that correct the lawyers even they work with to make sure they're precise.
of the incident, is there anything at all in your conclusions that was inconsistent with Ms. Benefield's description?
I can't think of anything that would necessarily be inconsistent. The key points that come to mind, where I remember her saying she stepped from her right to her left during the course of fire, that the decedent was moving rapidly in all sorts of patterns or manners, which would fit with the gunshot wounds entering the body in different angles. So from that perspective, no.
Give me just a moment, Your Honor, please.
Yes, sir.
I just have a couple.
So now we're going to get to cross. Okay. So he just explained all of that. And this is how the state crosses him. So Rochelle said, why didn't the state have the lead I think you mean the lead detective. And I think it's because the defense had stuff to tear him up on and they just didn't feel like they needed it. So it was a Proctor light, not necessarily to the Proctor level, but they just decided not to call him. I feel like I'm still confused and not convinced, which I believe as a juror, that means I'd have to vote not guilty. Is that correct? Yes. If you don't know what to believe and you don't really know what happened and you feel like it could go either way, that's a pretty strong not guilty stance in the American criminal justice system.
Quick questions. So you were able to give opinions about where the trajectory would be for the 2 shots into the walls, correct?
That's correct.
But as for the injuries into the human, you cannot opine about that.
That's correct. I don't have any other sort of anchors to bring the decedent's body into play with the scene because of the lack of perforation.
Okay.
So that's good. That throws a little shade on the precise level that he did this. He couldn't really take it into account the body as well for some of these measurements, it sounds like.
And with reference to the chest wound, I saw you kind of turning it several times. So, and we've had terms used such as front and side. So if you could just show the jury, where was this entrance wound?
To the best of my recollection, and of course, I could refresh my memory with images if it's helpful, but to the best of my recollection, it's in this general area on the side of the chest, and then it goes in, is recovered just under the skin in the back. So if you're sort of the firearm location, it would place the upper body in a vague general orientation like this.
So if you turned your body straight,
This way?
right, can you keep turning until you get to the point where, okay. So that's approximately the positioning of the gun to the body.
For the upper body, yes. I'd have no way of, correct, yeah.
Thank you. No further questions.
Redirect? No, sir.
That was it. So she had him stand, basically. She's holding the firearm with her hand, and that's how he's standing. Okay? That's not the front. That's not the back. How do you describe it? Does it look like somebody that's lunging, that's dodging out of the way maybe of the firearm? I don't know. What does that prove? What does that make you think? Then we get to the medical examiner who has done 5,000 autopsies. I could tell based on her background, she was mostly a prosecution witness, and I was waiting for the defense to get there. And at the very end, he's like, the vast majority of the 500 plus times you've testified, which side has it been for? And she said, usually the state attorney, which makes sense because she's the state medical examiner, or down in Broward County, I think she said. She said again, 3 gunshot wounds, explains the entry and the exit, front-sided, but not exactly straight on. Everybody seems to kind of agree with that. But the graze of the arm was the interesting part to me with how she used it, and we'll listen to some of it on cross. But once again, with all of these experts, when they're looking at the science and they're looking at the pictures and they're looking at the actual evidence in the case, the defense does a good job of asking, is that consistent with what Ashley Benefield said? And so far, they've all said yes, and he asks the medical examiner as well.
Dr. Liu, did you have an opportunity prior to your testifying here today to meet and observe and listen to Miss Benefield explain the events that took place on that day?
Yes, I did. It may have been last year that I did that.
Is there anything at all with respect to your findings that is inconsistent with the explanation Miss Benefield gave?
I believe that Mrs. Benefield's account is consistent with the evidence on the body, and I can demonstrate that.
So she believes Benefield's take is consistent with the body. She has multiple posters. She uses his law clerk as a demonstrative aid. We can't really see it perfect because it was kind of near the jury, but she goes through line by line where it went in, where it went out, what it's consistent with, and it's consistent with Ashley Benefield's story. Kathy, Peter, how does the stand your ground hearing get denied, but there's a possibility for not guilty self-defense trial? Wouldn't that be the same? Thanks for helping understand all this. So it's very different. It happens all the time. It happened in the last self-defense trial in Florida that we saw. Stand your ground, they lost, and then they won at trial and not guilty verdict. different things happen. It's the difference between a judge and a jury, different standards. It's not proving beyond a reasonable doubt. The state doesn't have to disprove it beyond a reasonable doubt. It's completely different standards, different rules, and it's a judge versus a jury. So it's actually very different. And it's really uncommon for them to win a stand your ground hearing, for a defendant to win a stand your ground hearing. Ashley, first super chat, Peter, is her explanation about the events that night enough to reasonably fear for her life, also admitting he'd never been physical? So here's what I would say. If you believe that he body checked her, he slapped her across the face, and he blocked her exit door, told her she's effing done and she's not leaving, I think if you believe that, that is absolutely enough to put a woman in fear for her life, an imminent fear of serious bodily harm or death. If somebody who's bigger and stronger than her, who has training, is in that position and has done those things, especially with the context of what she knows he said and has done in the past. That's my opinion. Now, I think the only way you find guilty is you just do, and I think the chat that thinks she's guilty will agree with me. They just do not believe her. They do not believe that's how the night went. And that's where it kind of teeters. So I would also ask for an explanation of the actual physical evidence as well. Unless you've been a victim of abuses verbally and physically or emotionally, you just don't understand the fear, in my opinion, not guilty. Dana said, the media is terrible about creating stories pre-trial. People get attached to a side not knowing admissible facts. I no longer watch pre-trial media coverage. Thank you for being you. Yeah, I have no idea. Honestly, I have no idea if the media was saying, let's get her, she did it with pitchforks, or if they were saying she's innocent and we're going to prove it. I had no idea. Same thing with Karen Reed. I had no idea. The state didn't prove self-defense to me, but he's gone and she did it. I guess I'd have to vote not guilty, yes. So she literally gets away with M. Potentially, if you think that that's a possibility, but again, you've got to hold the state to their burden, or else what's from stopping them from any other case being like, we're going to charge them, we're going to throw it out there, and we just hope they convict because they're the state, or we're the state. And we tell a story and we hope they kind of believe it enough. It's just not the way our system works. Okay. Then she talks about the leg position again and how it got there, and they have an explanation, right? And there's also an abrasion on his head that she says is evidence that he fell backwards potentially, which again would corroborate Ashley Benefield's story. The state has given us no explanation. On cross, the state's like, well, the EMTs could have just dragged him out of the house and hit his head on something. It's like, what? That's what you're saying? They just took him by the legs and dragged him out of the house and dragged his head on the ground? Like, that's wild that's the explanation the state has on cross. And then the last thing I want to play is redirect. Is this redirect? Let's see if this is the redirect.
This report corroborates that to the extent of, I think, 700. Ms. Benefield testified.
Let me see if I can find the redirect here of that witness. There were so many sidebars today and different evidentiary issues.
Maybe what movement they're braided.
And you would.
Benefield.
All right, here we go.
Dr. Lou would
This
be
is the redirect. This is the last thing we're going to listen to. So hit the like button if you guys haven't already.
abrasion wound to the Dr. Lou, would the abrasion wound to the right arm of Mr. Benefield be consistent with him lunging towards Miss Benefield?
Remember, the pathway is from front to back and upward. So if he was lunging and you were the shooter, you can see how that would be consistent.
That's all. Thank you.
Do you have any questions on that?
No.
All right, can this witness be released?
So, I mean, that's pretty good. So Deb said this doctor testified according to what Ashley told her. So Deb, it's important that we see the whole picture. Okay. So this doctor is the medical expert. She has been a medical expert, done 5,000 autopsies for the state. She looked at the body. She looked at the entry and exit wounds. She read the reports. So if Ashley Benefield would have made up a story that did not make sense with the evidence, she wouldn't have said it made sense with the evidence. If there was no gunshot grazing wound, she wouldn't have said, yeah, that grazing wound can happen with somebody lunging at you. If the entry was not here, she wouldn't have testified that something of being consistent with the entry here. She took what Ashley Benefield said and she applied the actual physical evidence she had. Now, did Ashley Benefield lie to her? Maybe. But this witness looked at the actual physical evidence as well and applied her expertise that she knows that I don't know. You don't, I mean, you may be a doctor, so I don't know. but that we as lay people don't know. She used her expertise to apply it and determine, does it fit in or does it not? Brenda said, reluctant, not guilty. So reluctant, not guilties happen all the time. And sometimes it sucks because you're like, maybe I think she did it, but the state just didn't prove it. And that is the state's job, or else it's not just. And it's really hard. I mean, the old Franklin quote that 100 guilty people should go free, that's better than one innocent person going to prison. I just gave a speech or a presentation, and that was in it. And it was with young, like, college students. And they were like, no way, I don't agree with that. And we started talking. And then eventually I was like, what if it was your brother was the one person? He's like, all right, yeah, I would. I'd rather, 100 guilty people go free than him being innocent and sent to prison. It's tough. It's tough. I don't pretend this stuff is easy, guys. And I really respect you going through the thought process with me and trying to think through this stuff logically. I really appreciate that because I know it's not easy. Oh yeah, let's throw up a poll. Kelsey, throw up a poll after the defense's case in chief. How would you vote? Guilty or not guilty? And then we'll do one more after rebuttal. I've got a couple questions, then I got to take off. Is previous DV a question they'd ask when choosing the jury? Thanks. I didn't watch jury selection. I'll just tell you, if I ever do a trial like this, yes, that's a question I ask. Regardless of what side I'm on, I want to know that. Maybe she provoked him that night. We will never know. Maybe he was fighting for his life, trying to get the gun from her. She will get away with it. So I agree. Maybe that is what happened. I really don't know. But I don't feel like the state has painted the picture to me to where I can really feel confident with an abiding conviction of guilt at this point. That's where I'm at. But I'm waiting because the state still has rebuttal. They go first and last. They have the burden, and they, you can put hung in there too, Kelsey. They have the burden of proof. And then undecided is fine. You don't have to vote yet if you're undecided. Don't vote hung if you're undecided. So the last thing I'll mention is the state said they're going to have kind of a quick rebuttal. It seems like only half the day tomorrow. Each side asked for an hour and a half, but thought they wouldn't actually take the full hour and a half for closing arguments. But those are going to happen tomorrow afternoon. And I don't know how this judge works. Either it's going to go straight to the jury at 3 or 4 o'clock in the afternoon, or Wednesday morning. And I'm actually playing golf Wednesday for the first time in a while for work stuff, with different vendors. So I'll be reacting to it if the verdict comes out on Wednesday, probably afterwards. We all know she did it. The state didn't prove it was M. So I don't know that I would say we know that she did it. I wouldn't say that. I feel if I had to choose, like, by a preponderance of the evidence, I would say it was self-defense, but I don't have to do that. The state has to disprove self-defense beyond a reasonable doubt, and we'll see if they can do that. Welcome to Mary and all the new members that joined today. That's awesome. And all the gifted members. Go back and watch the last Members Only Live we did. It was cool. It was a draft of your dream legal team. And we're going to announce the winning team here soon. If you haven't voted on it, go to the community poll and vote what your favorite legal dream team is. I drafted one, the chat drafted one, and John and Kelsey as kind of the behind the scenes team drafted one. Frank Muir was found guilty, and that was pure self-defense. All right. So we've got, over 1,000 votes. We have 13% saying guilty, 7% saying a hung jury, 80% saying not guilty at this point. That's been pretty consistent. That's been the percentages both times that we have done this vote. So we'll kind of see what happens from there. But I will be back tomorrow. Hopefully you guys will be back tomorrow. Make sure you hit the like button. Make sure you subscribe to our page and hit the reminder bell so you don't miss out on any future videos. And if anybody else is watching the trial, tell them to watch and get in the comments. I'd love to see more people's opinions and thoughts on this case. But for tonight, that's all we got. Until next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the lawyer you know.